everyone, this is Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about severing joint ownership. Now, one of the most common forms of property ownership in the United States is joint tenancy with rights of survivorship. But what is joint tenancy? Joint tenancy is a legal right to property that provides the owner with an undivided right to the enjoyment of the property. In other words, one joint tenant cannot legally stop the other joint tenant from enjoying the use of the entire property. Now, what does joint tenants with rights of survivorship mean? It means that when one joint tenant dies, the deceased joint tenant's share of the property automatically passes to the other joint tenant without the need for probate or any other formal proceedings. The survivorship feature of joint tenancy makes it very attractive to married couples and individuals who want to jointly own property with another person, maybe like an adult child, without any additional estate planning documents or sending their joint owner through the time-consuming and costly probate process. Because the joint interest passes by law to the survivor, there is very little that must be done to pass that property to the other joint tenant at death. And who doesn't like something that seems so easy? Well, at first impression, this method of ownership is attractive, as it generally is very inexpensive to establish and it works in a very simple and straightforward way. However, joint tenancy and its potential impacts on estate planning can, in certain circumstances, result in unanticipated and unwelcome legal consequences. It is important to note that there are other forms of joint ownership of property that we will not be discussing today at length. And that's tenants in common, life estates, remainder interest, community property ownership, and tenancy by the entirety. So today we're just going to focus on joint tenants with rights of survivorship, or joint tenancy. Joint tenancy can become undesirable in a number of common situations, including the following: a divorce of a married couple, when one joint tenant wants to sell the property but the other joint owner is refusing to sell it, one joint tenant changes his or her mind about who should receive the joint tenant's property interest at death, a spouse in a second marriage wants to leave their joint tenancy interest in the married couple's home to the children from the first marriage instead of to the spouse, for example. Now, joint tenants cannot agree on matters of management and upkeep of the property. Those are usually reasons why people choose to, or why it's beneficial to terminate the joint tenancy ownership. And in any of these cases, it may be time to do so because the actual outcome of joint tenants with rights of survivorship may be contrary to the joint tenant's current or future wishes. For example, if a divorcing couple continue to own property as joint tenants, then upon the death of one of them, the deceased spouse's interest in the property would pass to the ex-spouse rather than to the children or to the new spouse. Likewise, if a parent named only one child as a joint tenant on the deed to the family home, but later created a will expressing a wish to have all of the children share equally in the property, the deed would override the will and the entire interest in the property would pass to the one child who is listed on the deed as the joint tenant. Now, that child would have no legal obligation to follow the terms of the will. I see this all the time happen, and people just don't understand that if you own property with an adult child, when they pass away, that one and only child will be the sole owner. Now, there are several different ways to sever joint tenancy or joint ownership. You can do so by gifting, conveyance to a third party, divorce proceedings, buyouts sometimes, and judicial petitions. Now let's take a moment to talk about gifting. If the joint tenants are on good terms and can agree, the simplest way of severing a joint tenancy is for one of the joint tenants to file a new deed with the registry that transfers or gifts the property to the other joint tenant. This allows the individual receiving the property through the deed to own the entire interest in the property, with no one else having a right of survivorship. So upon the death of the owner, the property will pass according to the terms of the owner's will, or if none, to the owner's legal heirs determined by the state intestacy laws. One downside to this method is that federal transfer tax law is likely to treat the conveyance of property as a taxable gift. When someone makes a taxable gift of $15,000 or more in 1 year to one individual, federal law requires that person to file a gift tax return that would most likely need to be prepared by an experienced tax professional in most circumstances. Another option is to convey the joint tenancy interest in the property to a third party through a gift or through a sale. Doing so will convert the joint tenancy to a tenancy in common, which is another form of joint ownership. Tenancy in common is similar to joint tenancy in that the tenants have an undivided right to occupy and enjoy the property. However, there are no rights of survivorship between the tenants. Instead, at the first tenant in common's death, the property interest will either pass according to the deceased owner's will, or if there is no will, to the deceased owner's family through intestacy laws. In many states, such a conveyance can be made by a joint tenant unilaterally without the consent or without even providing notice to the other joint owner. A joint tenant can also convey the joint tenancy interest to himself or herself, which will sever the joint tenancy and create a tenancy in common. Such a conveyance must typically be recorded at the registry in order for it to be effective. And here in Mass and New Hampshire, it does need to be recorded. Though the law is not always consistent from state to state on the requirements for severing a joint tenancy. It's crucial that state law be consulted before any attempt to sever a joint tenancy to ensure that the applicable legal requirements are met in your state. It's also important to understand that in some states, if there's more than 2 tenants with rights of survivorship, the rule will create a last person standing situation, where the last surviving joint tenant will receive the entire interest in the property. However, in many states, if only one of the multiple joint tenants attempts to sever that joint tenancy by conveying that individual's interest to himself or herself or to a third party to create a tenancy in common, only that individual's equal interest in the property will be converted into a tenancy in common interest. The remaining joint tenants would continue to own their equal share interest as joint tenants with rights of survivorship just between themselves. So let's take a moment to talk about divorce. In a divorce proceeding where a couple owns property as joint tenancy, the judge will usually sever any property owned as joint tenants as part of the divorce decree. Doing so ensures that the parties to the divorce can go their separate ways with their separate property, rather than continuing to be tied together through joint ownership of what was once marital property. The divorce decree will often require that the appropriate real property documents, the deeds, be prepared and filed with the registry's office to officially sever the joint tenancy. In many cases, the attorneys representing the divorcing spouses will assist in preparing and recording such paperwork with the registries. Another method for severing a joint tenancy is for one of the joint tenants to simply make an offer to purchase the other joint tenant's interest in the property. If the joint tenants agree on a purchase price, the seller prepares a deed to convey the real property to the other joint owner. The deed is then recorded with the Registry of Deeds, thereby severing the joint tenancy ownership. When joint tenancy between non-married individuals becomes a source of disagreement or conflict, it may be necessary to seek a judicial petition of the property. This remedy requires one or more of the joint tenants to seek help from a court and ask a judge to divide the property fairly between the joint tenants. The petition can be done in kind by drawing boundaries through the land and allocating equal portions of the land among the joint tenants. Alternatively, if such physical division is impossible due to the nature of the property, the court can order that the land be sold and the proceeds of the sale be divided equally between the parties. Judicial petitions can be costly and time-consuming, And in the case of a forced sale of the property, it can trigger recognition of capital gains on the property, resulting in unwelcome tax liability for the parties. As a result, you should reserve judicial petition as a remedy of last resort if possible. Now, in certain circumstances, joint tenancy can be a simple and effective method of jointly owning and transferring property at the death of one of the joint owners. Nevertheless, joint tenancy can also have serious unintended consequences. Many individuals fail to realize that joint tenancy survivorship provisions will nearly always override the provisions of a will or a trust agreement. It is therefore crucial that someone who owns joint tenancy property seek the advice of an estate planning attorney when using joint tenancy as a tool for estate planning. Without careful consideration and planning of your estate, using joint tenancy improperly could unintentionally set your loved ones up for significant misunderstanding and legal expense. If you have any questions about your real property and how it relates to your estate planning, please give us a call. We're available for in-person or virtual consultations, whichever you prefer. I hope that you all found this helpful. If you have any additional questions, please reach out to us at Kelly Longtin Law. I'm Kelly Longtin, owner and founder of Kelly Longtin Law.